associated with those impacts and unnecessary costs thrown away through the wasted resources of the tribunal. The conduct of other matters, including matters where the parties have dutifully complied with orders made, are unnecessarily delayed. There are a number of reasons as to why an occasional lapse in compliance with orders, rules and practice directions of the tribunal may occur. However, there can be no justification for the persistent failure to comply in this matter with the associated failure to communicate with the tribunal. In most instances, parties are represented by members of the legal profession. That has been so in this matter. There is a professional duty to comply with orders of the tribunal and to keep the tribunal properly informed of important developments in the proceeding. In this case, the deficiencies are also associated with the corporation, which is a regular party to proceedings in this jurisdiction, and that is an additional concern. The deficiencies in this matter are not isolated. Indeed, they may have become too commonplace in this jurisdiction. Perhaps the tribunal has been too tolerant in the past in relation to the failure to comply with its orders in a timely manner. Parties should not expect such an approach to be ongoing." End quote from the tribunal. And sure enough, in the years since, we've not seen the conduct of the corporation improve. They have continued to fail to account for certain decisions. And we are now faced with the threat of the increase of premiums above 2%, unless we are told Parliament acts. And that action, the government has been told by the corporation, should mean less access to fair compensation for injured workers. Because apparently, according to the Return to Work essay, too many workers accessing the compensation that on paper in the Act are rightfully owed them threatens the scheme. If the scheme is broken, it needs a proper and open review. Undercutting injured workers cannot be the answer. Injured workers shouldn't have to suffer in poverty to cover return to work of South Australia's negligence. The Return to Work Board and corporation have kept premiums artificially low by essentially breaking, or at least not implementing, the law as intended and as supported by multiple court decisions. It is clearer now than ever that the Return to Work Board and corporation have fundamentally mismanaged the scheme, and injured workers continue to pay the price for their incompetence. If a workers' compensation scheme is deemed to be unstable when it actually has to provide compensation to workers, it is not a scheme worth having, and perhaps we should start from scratch. But most importantly, a government elected off the back of a Labor movement should not be making injured workers bear the cost of the mistakes of an unelected board. It has been abundantly clear from every conversation we have had along the way in consulting and considering this and the previous bill that something is clearly wrong. This board has been unaccountable, lacking in transparency, and they have wilfully ignored and failed to account for their court losses over a series of years. Businesses have received artificially low insurance premiums, while injured workers have missed out on fair compensation as a result. This cannot be how a workers' compensation scheme operates, and the Greens will be having more to say about the Return to Work Board itself and what we can and must do to fix that later this week. The unionists, the workers, the door knockers and campaigners who got this government into power, they still probably have blisters on their feet to show for that hard work. And yet, is this legislation really how the Malinauskas government thanks them for their efforts? Does the Malinauskas Labor government represent the Labor movement, thanking them for their support through those years in opposition and thanking them for their hard work to get a Labor government back at both state and federal level by immediately discarding them after those elections, by ignoring their concerns, their voices and their feedback? Is this the future that Labor said it was standing for throughout their campaign? I hope not. A future where injured workers are discarded for the whims of an unelected board, a future where the Labor movement is tossed aside to placate businesses and corporations ahead of considering other options, that is a bleak future. And I'm quite confident that that is not the future that South Australians voted for. Now, having said all that, the Greens do recognise this bill is an improvement on the original version put forward, and that the government has gone further to address concerns and fix problems with their suite of amendments. But what continues to be our key concern is the fact that despite the positive steps forward taken with enshrining the Summerfield principles and providing better access to redemptions, this bill still raises the whole person impairment threshold to be considered a seriously injured worker up to 35% for physical injuries. It is the opinion of the Greens that the 30% threshold for both physical and psychiatric injuries was already too high, which we flagged during the original debate back in 2014. Even then, this of course means that pretty much only those with near catastrophic injuries would meet that test. I cannot imagine a 35% threshold being any better for workers, even when the government argues that workers will be able to combine their injuries now, which would make the threshold more attainable for some. Arguably, they already could. That's the point, really, and they have already struggled to meet the 30% threshold for fair compensation. We are not unique in our concerns around the already high and about to be higher threshold. Back in 2017, the Parliamentary Committee on Occupational Safety, Rehabilitation and Compensation conducted an inquiry into the Return to Work Act and scheme. That committee's report notes the problems and inconsistencies with this threshold, stating, and I quote, "The committee notes that whole person impairment assessment is not necessarily indicative of an individual's ability to work. The Australian Education Union and others argued by solely using this threshold, it would result in workers who are unable to work but still have their payments ceased at 104 weeks, as they do not meet the criteria for ongoing support." Further, witnesses providing evidence to that committee described the threshold as a, quote, "actuarially devised contrivance," end quote. And I can't see how this debate and this bill do anything other than prove that true. These numbers, these arbitrary thresholds, do nothing to aid injured workers and are designed purely for the financial benefit of the scheme and the corporation. While we were glad to see the withdrawal of the original bill, and we voted for that to be discharged, it must be said that the current bill, as it currently stands, unamended, has some quite serious and concerning deficiencies that would leave workers worse off. For one, the bill as introduced doesn't actually enshrine the Summerfield principle, which was one of the main reasons we were told that this legislation would be brought forward. This is, of course, proposed to be addressed in government amendments to the bill, and I do commend the work of the Honourable Connie Benares on this particular matter in particular. But it is rather a large oversight to have missed in the original version of this bill. Further unamended, the bill would deny lump sum economic loss payments for a number of workers who sustain later work injuries after a first work injury. The proposed amendments to section 56(6) mean that any worker who suffers a further injury unrelated to their first injury will no longer receive any lump sum if their subsequent injuries are determined as less serious than their first injury, regardless of how that injury impacts their ability to work. This is deeply concerning and has been raised as an issue with us by several stakeholders, though we are pleased that the government has now filed amendments that will remove those changes. That being said, it is concerning that this change was entertained in the first place. Perhaps this could have been avoided had the bill been properly consulted upon from the outset and not put together in such a rush. I could go on, Mr President, but I certainly want to get on with the debate today. There are multiple sections of this bill that have needed serious work over the past few weeks, and while that work has now largely been done and is reflected in the amendments that have been filed, it is concerning to think that the government hasn't thought to do this work in the first place, and that it has fallen on unions, businesses, lawyers and workers to identify some of the serious deficiencies and omissions in the original government bill. The Greens do appreciate the constructive nature with which the government has handled our concerns and the concerns raised and their willingness to make these amendments. But we, like so many others, have been frustrated that the consultation process has essentially happened backwards. And that's what we're left with, trying to find small fixes for sub-optimal legislation. With that in mind, the Greens are of the view that many amendments need to get through this committee stage and be made to make this legislation more tolerable. Because unamended, the bill is a disaster. And we flag now that any future reviews of the Return to Work scheme and legislation, which the government has committed to do, need to be far more thorough, timely and well consulted. We cannot and we will not accept further attacks on injured workers. And I note, and I'm sure others will as well, we will have many questions during the committee stage and look forward to the Minister's prompt and detailed responses. placing those matters on record. It is vital that we have complete information when voting on this bill, and the Greens will be watching and participating in that debate on the proposed amendments closely. And I flag that that debate will shape our vote at the third reading. I also note correspondence that I received yesterday from Dale Beasley, who is the Secretary of SA Unions. And he wrote to me following an executive meeting of SA Unions with Dear Tammy, "It is the strongly held view of SA Unions that the precedent set by the outcome of the Summerfield case represents the true and proper application of the law. Those principles are foundational, and protecting the combining principles of Summerfield has been a central concern of the union movement as we have engaged with the government over their return to work amendment bills. The bill proposed by the government does not have our universal support. There are many things which we advocated for, and some of those things were not achieved. However, the current package of amendments do contain protections of the Summerfield principles and many other measures which we support. And importantly, the government have also committed to reviews of the system to consider its management and effectiveness and how both could be improved in an ongoing manner. Faced with the alternatives, the original bill that proposed to undo the Summerfield decision or continue litigation of combination injuries, it is difficult to see how passing the government's current bill with the amendments currently proposed that add protections for injured workers could be criticised. As far as unions are concerned, the work to improve the right of injured workers does not stop here. The return to work system is still one stacked against injured workers, and our united union movement is committed to continue campaigning for improvements to ensure workers received the highest possible levels of support. We will continue pursuing necessary improvements to the system, be they legislative, organisational or cultural, and hope that we will continue to be able to rely on your support. Kind regards, Dale Beasley, who is the Secretary of SA Unions. I share that with the Council because I received that after 4 p.m. yesterday, and so I know not all members of the Council may have been privy to that particular correspondence. With that, we do intend to support the second reading, participate in the committee stages and reserve our right at third reading.